1/3 of all licensed physicians at some point in their career will encounter the unfortunate event of a medical malpractice claim being asserted against them.
Thank you for tuning into Brock Eichler Talks, where we explore and discuss today's trending legal topics. My name is Joseph Cameron, and today I'm here with Brock Eichler member Keith Roberts. Keith is certified by the Supreme Court of New Jersey as a certified civil trial attorney. He is also the chair of Brock Eichler's litigation department. Keith has extensive litigation experience representing clients in some of the largest, most complex, and high-exposure cases with an in-depth understanding of the law and a command of the facts to strategically achieve his clients' litigation objectives. As a member of the healthcare team at Brock Eichler, Keith is often called upon to represent hospital systems, surgical centers, medical practices, and a wide array of healthcare professionals in complex litigation matters. How are you doing, Keith?
I'm doing well, Joe. Good morning.
Thank you for joining us. And for everyone out there, our litigation department is award-winning. We have won Litigation Department of the Year for 3 years in a row. So congratulations on that, Keith.
Thank you, Joe, for mentioning that we were recognized by American Law Media through the New Jersey Journal Awards program as the Healthcare Department Litigation Group of the Year. So I'm pleased to have you acknowledge that, as the team worked really hard given our submissions and our accomplishments to date. So thank you.
All right. So before we move on, how about you tell us a little bit about yourself?
So I joined Brock Eichler in 2011. I previously had been a solo practitioner for a while. I also had a small firm with my prior partner. That firm was in River Edge, New Jersey. It was Roberts and Moscotolo. And prior to that, I was a member at a firm called Maggiano, DiGirolamo, and Lizzie. I was a trial attorney there for many years. So I had started actually out in a boutique firm, learning how to try cases and practiced in the personal injury space for quite some time, but naturally gravitated and developed a healthcare law practice where I counseled physicians in various types of proceedings: civil proceedings, disciplinary proceedings, insurance carrier-related fraud defense. I mean, it's a pretty widespread area to include labor and contract disputes, restrictive covenants. So because of my in-depth experience at both personal injury and commercial-related litigation, I gravitated towards healthcare as an interest and grew that specific area over time to where I am now, representing various practices across the state of New Jersey, physicians across the state of New Jersey. I counsel hospital systems, large facilities. So the practice has now evolved with a heavy emphasis on healthcare-related litigation, although we also, the department services commercial litigation at a high level. Our practice areas include appellate matters, business and commercial litigation, complex healthcare litigation, contract and vendor disputes. We have a white-collar defense aspect to our ability to provide defense in various claims in the litigation department. We have a robust area in employment. In addition to that, governmental regulations, everything related to healthcare and regulatory matters we counsel on in contested proceedings. Insurance fraud is an area that we excel at. We're clearly experts there. We appear before the state boards on a regular basis to defend physicians. We have an outstanding personal injury department, its own separate department at the firm that is, in my mind, led by some of the best lawyers in the space, which is also doing very well and expanding. So we continue to lead the way, in my mind, for a firm of our size as it concerns litigation needs.
That's amazing, and your credentials are something truly impressive. So today we'll be talking about medical malpractice. I'm certain you're familiar with the fact that physicians are often sued for medical malpractice. As a litigator and healthcare lawyer, are there any tips that come to mind for physicians to consider?
Well, that's a good question. So there are certainly things I think physicians should consider in the unfortunate event that they're served with a complaint for malpractice. Regrettably, I have to say that in the United States, this is according to the American Medical Association, 1/3 of all licensed physicians at some point in their career will encounter the unfortunate event of a medical malpractice claim being asserted against them. Now, that's a high-level statement because each claim obviously is focused upon the individual circumstances, and it's going to be highly fact-sensitive. You may be involved at the periphery of the care and not be directly involved, and that may be a claim that's easily defended, perhaps dismissed. You may be the focus of a claim. But in any instance, I think there is some general advice that we can give to address how a physician would react in the event he or she receives a complaint. So you have to be first responsible. You have to take it seriously. You should report it to your insurance carrier. And very, very important that you retain counsel. Now, I would say in most instances, your insurance carrier, when they receive the claim, depending on the nature of the claim and how far along it is, if it's an actual complaint, a lawsuit where you're named as a defendant, you're going to be assigned counsel. They have a panel of lawyers that they approve to represent their policyholders, which is what the physician would be, and insured. You then get assigned counsel, and you develop a relationship with that counsel. Now, there are areas where you might need private counsel in addition to your regular counsel assigned by the insurance company. Sometimes we call that special outside counsel, or sometimes by lawyers it's referred to as personal counsel or excess counsel, which means maybe you're underinsured for the event. Maybe the event is one that is a serious one, and your insurance carrier has X amount of coverage available to you pursuant to the policy terms or your policy limits. But there's a concern that that's going to be inadequate and that the damage claim will exceed that. Not an ideal place to be, but it happens. In that scenario, you would want to have your own lawyer to counsel you and provide support and work side by side with the carrier assigned by the insurance carrier. And that interplay is a little bit complicated, but it's something you seriously want to consider. You may also want to consider a lawyer who would just provide you with some advice and counsel separate from your insurance company lawyer to help guide you through the process. There's nothing improper about that as long as it's coordinated properly. So that would be one thing that you'd want to consider, reporting it and acting responsibly and getting counsel. Now, there are other things, Joe, that people sometimes don't think about, which I think are very important. People tend to react badly and emotionally. No one wants to be sued. So what you want to think about is get yourself in the mindset of, hey, this is unfortunate and something occurred where a patient is very unhappy. Maybe it's just at this point a complaint by way of a letter. Maybe it's not a lawsuit. But in either scenario, whether it's a formal action or not, you want to look at it as, okay, I have to act in a very professional manner, and I have to now take the necessary steps that are responsible for me to do, which means communicating with your patient if the patient was to be able to get a hold of you or call you or have a conversation with you, and be very respectful and making sure there's an open process there that lends itself to cooperation rather than hostility. So I think you want to get your mindset correctly regardless of how upset you might be, and you want to act appropriately. So those would be the first immediate things I would counsel a physician on as it concerns being the target of a complaint from a patient.
What should a physician be thinking about when he or she is sued for medical malpractice?
Well, that dovetails into the last part of my answer to the first question you asked, which is not only setting your mindset, but making sure you act appropriately. There's going to be people reaching out, right? The insurance company is going to contact you. Perhaps the patient himself or herself or the patient's lawyer or representative, guardian, whoever, will be looking to contact you or your office. Make certain that every person that comes into contact with these individuals is respectful, cooperative, polite. It's not the time for apologies. Apologies can be accepted as admissions or viewed as admissions. Perhaps you may say, gee, I'm sorry you had a bad experience, or you feel you did, but nothing along the lines of, hey, I'm sorry for what happened. I apologize. I made a mistake. That's not proper. Some people may feel compelled to say those things to diffuse a situation. You don't want to do that. What you want to do is be cooperative be professional. Sometimes, believe it or not, communication with either the patient or the patient's representatives resolves the issue. It could very well be that the issue gets resolved because the patient feels their concern was addressed or the issue they had was properly taken care of or properly remedied. It could really just be a communication issue or confusion about something before it even gets to the level where they want to file a complaint. That does happen. So you're getting yourself in the right professional mindset and having the right people, like your lawyer and the people from the insurance carrier that are going to reach out to you, and your staff, having people address it and evaluate it for what it is and acting in a professional and responsible manner in reaction to it may be able to resolve it. I'm not saying that's going to happen all the time, but may be able to be resolve it at the outset. And maybe it'll never turn into a litigation. I can assure you that acting in a hostile way or acting in an inappropriate way will not help the situation. And oftentimes it aggravates it. So that's a very important piece you want to be thinking about. In addition to that, you also want to be thinking about how to get organized. There's going to be a records request. It's going to require some of your time and attention to consider what went on. Maybe there's something you need to change in your practice. You have to examine the underlying circumstances. Maybe there are things you want to improve going forward. You want to look at what the root cause is of the complaint, and you want to, in a very professional manner, address that. So those are things at the outset that you want to think about in the event you receive a complaint or you're sued.
That information is going to be really valuable to a lot of people. What can you tell us about what a person has to prove when suing a doctor for medical malpractice?
Yeah, so as I indicated a few moments ago, it's important not to be confrontational with anybody in the process. That's not going to be helpful. And, keep in mind that these cases are not easy cases. Now, there are situations where someone makes a mistake and it's clear. We've had, unfortunately, people have operations at the wrong anatomical site. Those are black and white cases. There are other cases that are not so clear. And it may just be that the perception of the patient, and this includes lawyers, are mistaken about the risk involved, about whether or not the consent was proper, about the nature of the procedure or the treatment itself, and what it was supposed to yield by way of results, and what is or what is not what we discuss as within the accepted standard of care. So your question is what a patient has to prove. Well, you need to prove that there's a deviation from the standard of care. And not only was there a deviation, but that deviation, what we call proximately caused, but in plain English, directly led to damages, to your resulting damages. And whether or not those damages are permanent and what the nature of those damages are also a very important consideration. These are not easy cases. Doctors have adequate protection. Medicine is not a perfect science. Yes, mistakes are made, and unfortunately, people at times suffer from those mistakes, and there are legitimate claims that go forward. But the claims themselves and the nature of the evidentiary process provides adequate protection for physicians who act within the standard of care, which physicians know what that is, and appropriately address their patients by way of consent and process and privacy and security and protection of their medical record. So with all that being in place, generally the cases can be difficult to prove. It's not an easy standard. So it takes experienced counsel on the plaintiff side to be able to navigate perfecting a claim and getting it filed and actually converting it to a damage claim. So physicians should keep that in mind, and that's why you should consult a lawyer who is experienced. Some of the lawyers that they work with are exclusively only do medical malpractice defense. So you will be speaking to an experienced lawyer in all likelihood. You can also seek one out if you're uncomfortable and you want to speak to a lawyer who you can determine for yourself by reviewing their bio has the appropriate experience to counsel you. So these are the things that you want to think about, and an answer to your question. I would call the bar as reasonably high in a medical malpractice case. And for lawyers, they're expensive to litigate. It becomes about experts. It becomes about proving and establishing a damage claim. They're not simple matters. So you want to think about as a doctor that, hey, the law has adequate protection for me. Let me get appropriate counsel. And then both lawyers are immediately going to look at, no matter which side of the ball you're on, what's the likelihood that this claim will be successful and why. And the doctors, to the extent they want to be, or may be very actively engaged in those conversations, and they'll be educated about the nature of the claim and what changes they can make going forward to avoid the same or similar claim in the future.
And Keith, there may be some doctors listening that have received a complaint or may receive a complaint in the future. What advice would you have for a doctor who receives a complaint as it concerns immediate next steps he or she might take?
So in addition to what I've said about getting your mind in the right place, getting prepared to produce records, getting your staff organized so that people are treated respectfully and there's cooperation and you're reporting it to your carrier and you're retaining counsel, going beyond that, it's important to realize that you have responsibilities as a physician. So according to the Board of Medical Examiner applicable regulations, you have an obligation to produce the records. If you're really at a conflict with your patient at this point, you're going to transfer care if that's care's ongoing. You're going to responsibly transfer care. So you want to consider those things. You also want to think about beginning to prepare your defense, but that is going to require counsel. You do not want to do anything such as alter a medical record or create some type of inference that you did something improper in reaction to the notice of the claim. Keep the records intact, exactly how they are. They'll be both the foundation for the claim, but also the foundation for your defense. So you don't want to do anything that would lead to a claim of what we call spoliation, where you either destroyed or manipulated evidence. You don't want to be in that situation. And I'm not suggesting that someone would do it as a matter of being unethical or doing something improper. People do it because they open up a record. Oh, this information is missing, and I know it's accurate. I know it to be truthful because I have this information outside the chart documented here. Let me get that in the record. Before you do anything to add, subtract, whatever it may be from a patient record, I don't care if it's the billing record, the patient record, speak to your lawyer about how you would effectively make that occur so that it's properly utilized to your defense and not weaponized against you later. So that's important. And that's probably the most important thing beyond what I said before, which is the respectful communication and cooperation with the process and avoiding apologies where they would not be appropriate. So respect, communication, transferring care, getting records ready for transfer. These are the things you want to be thinking about, and counsel will help guide you through that process.
And that leads us right into our last question. Is there anything that you might advise a doctor not to do after being served with a lawsuit?
Yeah, I think the things you do not want to do. You don't want to get into a confrontation with anybody, especially the patient. You do not want to do anything to inflame the situation. You do not want to make an important decision without speaking to your carrier and your counsel that's been assigned or your personal counsel. You do not want to do any of those things. You do not want to be emotional about it with anyone, whether it be your staff, whether it be the patient, which by way of either not only just confrontation, but you don't want to do the opposite either. You don't want to do anything to placate the patient or try to suggest some resolution because you're afraid of the claim or the consequences of the process to follow. You don't want to do anything to disrupt what is the orderly, natural, and legal process that will follow. You don't want to disrupt that. You want to be a professional and participate in that. I would strongly suggest that you speak to your lawyer, you get your head in the right place, you get your feet set, and you, in a very organized and professional and respectful manner, you prepare your defense, and you communicate with those for which you will be required to do. And that could include a medical board. It could include the physician and his or her representatives, and your own staff, and your own insurance carrier, and that lawyer. So don't take it upon yourself to try and improve the situation, thwart the claim, or, hey, you know what, I can fix this. Get so-and-so on the phone. We're going to get this worked out. Mistake. Do not do that. A lawsuit of this nature can be a very serious thing. In the worst case scenario, it's a life-altering thing. You don't want to do anything without the appropriate professional advice. So that's a big part, if not the most important part, of what you want to consider in the event of an unfortunate occurrence of a complaint.
Thank you, Keith. I know how valuable your time is, and I think all these tips and this discussion is going to be very helpful to a lot of people. If there's anybody listening that wants to get in contact with you, how can they do that?
So two things. I think, number one, I just want to mention that I published on this subject, and it was picked up by various media outlets. We'll drop a link to that. There was a source in there from Bloomberg that talks about the frequency of these types of complaints against physicians. We'll drop that link as well. You can reach me at kroberts@brockeichler.com. I'm available. You can shoot me an email. You can hit me up on LinkedIn. I'm pretty accessible. So if you get in touch with me, I'm likely to share my cell phone number. It seems that everybody has it these days. So I am not hard to find. So, Joe, thank you for your time.
And thank you, and I hope we have you on here again soon.
Thanks, Joe. I appreciate it.
Thank you for listening, and for more information, please visit brockeichler.com. Brock Eichler LLC is a full-service law firm based in Roseland, New Jersey. With over 80 attorneys, the firm is focused on the following practice areas: healthcare law, real estate, litigation, trust and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property and information technology, real estate tax appeals, tax, and cannabis law. No aspect of this advertisement has been approved by the Supreme Court of New Jersey. For awards and honors methodology, visit brockeichler.com.